Under Maryland law, a person has the capacity to enter into a valid real estate contract at age 18. However, minors married to persons who have reached the legal age may enter into valid real estate contracts jointly with their spouses. In general, competency has three requirements: age, state of mind, and authority to act. Statute of Frauds states that all contracts must be in writing. Leases for 1 year or less are the exception. Comer Code of Ethics says all agreements are to be put into writing. Rather than oral agreements, no exceptions. Duties and obligations of licensees: prompt presentation of all written offers and counteroffers, obtaining proper signatures on all forms, putting all agreements into written form that clearly state all obligations of the parties, and giving and retaining copies of all signed agreements. Keep these records a minimum of 5 years. Licensees are obligated to use pre-printed forms through their brokerage or their membership with the state or local association. Licensees who write their own contract terms could be found guilty of unauthorized practice of the law and be fined $5,000 and/or 1 year of imprisonment. Required sales contract clauses include Chesapeake and Atlantic Coastal Bay's critical area. This clause is required in all contracts for all counties, even those that are not included in the critical area. Buyer is advised that all or portion of the area may be located in the critical area, and that additional zoning, land use, and resource protection regulations apply in this area. The local Department of Planning and Zoning maintains maps showing the extent of the critical area in the jurisdiction. A notice using the following wording must appear in residential sales transactions in all areas except Allegheny, Carroll, Howard, Frederick, Garrett, Montgomery, and Washington counties. Buyer is advised that the property may be located near a military installation that conducts flight operations, munitions testing, or military operations that may result in high noise levels. Sellers must disclose any existing expense for deferred water and sewage charges, also called tap fees or front-foot benefits. Failure to provide this information would allow the buyer to rescind the contract before settlement. If the buyer does not learn of the expense until after, the seller is responsible for paying the remaining amount of all recorded fees. Builders must disclose to purchasers on a state-mandated form whether they participate in a new home warranty security plan and the extent of that plan. Financing contingencies are now required in new home sales contracts. Residential lease purchase option agreement is not valid in Maryland unless it states in capital letters, "This is not a contract to buy." An attorney in fact is a person whom authority is granted by a document called power of attorney. A buyer receives equitable title when a contract of sale has been signed by all parties. The buyer will not receive legal title until the delivery and acceptance of the deed. For more videos like this, please like and subscribe. Thanks for watching.